left my son on the front steps of his own house with nothing but a garbage bag and his little boy's backpack. His mother-in-law changed the locks while he was at work. His wife filed for an emergency protection order based on things that never happened. They told the court he was dangerous. They told his son that Daddy wasn't coming back. What they didn't know, what none of them had ever thought to ask, was whose name was on the deed to that house. Mine. I told my son to get in the truck. He stood on that sidewalk in Kanata, looking like a man who'd forgotten how to breathe. His 6-year-old gripping his hand, both of them in November coats, without scarves, without hats. The kind of detail that breaks a grandmother's heart. The hats. The kind of detail that breaks a grandmother's heart. The hat. Whoever rushed them out hadn't given them time to grab a hat. My son-in-law, the man I'd watched smile through our family Thanksgiving for 4 years, had apparently decided that a restraining order was easier than a conversation. My daughter-in-law's mother had decided the same thing. And my son, my gentle, hard-working son who drove 2 hours to Ottawa every Christmas with homemade butter tarts and a trunk full of presents, stood on a public sidewalk not knowing what to do. I knew exactly what to do. "Get in the truck," I said again. He looked at me the way he used to when he was 8 and had broken something, like he expected me to be angry. I wasn't angry. Not yet. The drive to my house in El Monte took 45 minutes. My grandson fell asleep against his father's arm somewhere past Carlton Place, still clutching the straps of his backpack. My son stared at the window. He didn't speak until we pulled into my driveway. "Mom?" His voice was thin. "I don't understand what I did." I parked the truck, looked at him. "You didn't do anything. That's not what this is about." He shook his head. "She said I was controlling. She said I made her afraid." I turned off the engine. The porch light was on. My house looked the same as it always had. 2 stories, stone facade, the flower boxes I'd planted with my late husband the year we bought it. 31 years ago, paid off in full by the time my son was in high school. "Let's get your boy inside," I said. "Then we'll talk." I made tea. My son sat at my kitchen table and told me everything in pieces, the way a person does when they're still in shock, when the story hasn't finished assembling itself in their own mind yet. He told me about the past year, the arguments that came from nowhere, the way his wife had started disappearing for evenings and not explaining where she'd been, the way her mother had started appearing, first for weekends, then for weeks at a time, sleeping in the guest room, watching everything with those quiet, assessing eyes. He told me she'd started talking to a lawyer in September. The protection order had been filed on Tuesday. It was Thursday. I waited until he finished. Then I asked one question. "Did you ever sign the deed transfer I offered you last spring?" He frowned. "No. You said we could do it whenever. There was no rush." I nodded. "Good." He stared at me. "Mom, what does that have to do with—" "The house," I said, "is still in my name. Through a family trust I set up with my estate lawyer in 2019. I put it in trust because I wanted to protect your inheritance in the event of a marital breakdown. Standard practice, I'd been told. I hadn't expected to need it this soon." My son was quiet for a long moment. "She thinks she can fight for the house in the divorce," I said. "Her mother thinks the same thing. What they don't know is that there's nothing to fight for. That house was never an asset in your marriage. It was always mine." He put his head in his hands. I reached across the table and put my hand on his arm. "I'm not telling you this to make you feel better," I said. "I'm telling you because you need to understand what position you're actually in. They moved first because they thought they held all the cards. They don't." I waited until my grandson was asleep in the back bedroom before I called my estate lawyer, Corinne. She'd handled my husband's estate and she'd set up the family trust. She answered on the first ring. I texted her from the driveway. I explained the situation. She was quiet in the way that lawyers get when they're already thinking 3 steps ahead. "The protection order changes things temporarily," she said. "He can't return to the property while it's in effect, but the ownership question is completely separate from the family law question. If the house is held in trust under your name, it isn't matrimonial property under the Family Law Act. It never was." "What do I need to do?" file an affidavit confirming the trust arrangement, get me the documents by morning, and I can have a motion prepared by end of day tomorrow. Done. I also want you to pull everything, I said. Every property record, every financial document connected to my daughter-in-law's family. Corinne paused. What are you looking for? I thought about those eyes, the way my daughter-in-law's mother had looked at my kitchen at Thanksgiving 2 years ago, the way she'd asked, almost casually, what the property taxes were on my son's house, what the neighborhood was trending. She wasn't visiting, I said. She was appraising. I hung up and poured myself a second cup of tea, stood at the kitchen window looking out at the backyard, at the old maple my husband planted when our son was born, 40 years ago, give or take. My daughter-in-law wasn't a bad person, not in the way people usually mean. She hadn't started that way. But her mother was something else. I'd watched Glenda Forsythe operate for 4 years, and I'd kept my mouth shut because it wasn't my marriage, and because my son seemed happy, mostly, and because some battles you choose not to fight until you absolutely have to. I was done choosing not to fight. What my son didn't know, what he had no reason to know, was that the commercial property management company his wife had worked for since they married, the one that had given her a title and a salary and the reason to travel to Toronto every second week, was managed through a holding company. I'd known the principals since 1998. I'd done a quiet favor for their predecessor firm in the early 2000s when my own property development business was finding its footing, and people in that industry remembered. When my daughter-in-law had mentioned the company name at dinner one evening 2 years ago, I'd made a single phone call the next morning, not to interfere, just to know. The call I made that Thursday night was different. By Friday morning, I had a folder on my kitchen table that Corinne's paralegal had couriered over before 8 o'clock. Property holdings, corporate filings, a financial disclosure my daughter-in-law had filed as part of the protection order process. I read every page with my second coffee going cold beside me. The picture that emerged was not subtle. Glenda Forsythe had been living in the Canada house, effectively for nearly a year. She'd redirected her own mailing address there. She'd applied for a home equity line of credit using the property address, the address of a house she did not own and had no legal claim to, as her primary residence. The application had not yet been approved. It was sitting in a queue at a bank that didn't know the house was held in trust. I set down the folder. They weren't just trying to take my son's marriage apart. They were trying to take his house, my house. My son came downstairs just after 9. My grandson was still sleeping. My son looked like a man who hadn't slept at all, which was accurate. I showed him the HELOC application. He read it twice. She told me her mother was helping with the mortgage, he said finally. There is no mortgage, I said. There hasn't been one since 2021. The house has been held in trust, free and clear. He set the paper down. His hands were steady, but his jaw was tight. What did they think they were going to do? I think your mother-in-law planned to establish residency, I said, refinance against the equity, and use your marital breakdown as cover. If the protection order stuck and the divorce proceeded, she'd have had a claim to half the equity. Or she thought she would. My son looked at me. How long have you known? I didn't know, I said. I suspected. I set things up carefully because I suspected. There's a difference. He was quiet. I refilled his coffee, sat down across from him. Your job right now, I said, is your son. I'll handle the rest, but I need you to trust me, and I need you to let Corinne do her work without interfering. He looked at my grandson's backpack sitting by the door. I trust you, Mom. The family court motion was filed by noon. By 3 o'clock, Glenda Forsythe's lawyer, a man in Nepean who'd apparently been briefed by phone from a Tim Hortons parking lot based on the quality of his response, had received notice that the house in question was not matrimonial property and never had been. I was told he called back twice. At 4:15, my daughter-in-law called my son's cell. He put it on speaker without being asked. I sat at the other end of the kitchen table and said nothing. Her voice was tight. She said the lawyers were saying there was some kind of issue with the house. My son said yes, it seemed there was. She said her mother had invested in the property, that she deserved to be protected. My son said she was welcome to provide documentation of any investment to his lawyer. She paused, then she said, "Your mother did this." My son didn't answer right away. I watched his face. He looked tired. He looked sad. But he didn't look confused anymore. And that was something. "My mother," he said finally, "protected her family, same as yours was trying to." The line was quiet for a moment. Then she said, "This isn't over." He said, "I know." She hung up. I went back to my folder. What came next took several weeks. I won't pretend it was clean or simple. Family law in Ontario isn't designed for speed, and protection orders, even unfounded ones, carry real weight in the short term. My son slept in my spare room. My grandson started a temporary school enrollment in El Monte, which he handled better than any of us. He liked his new teacher, and he liked that his grandmother made porridge on cold mornings and that there was a cat. The cat was named Douglas, and he was not impressive, but he was warm and he sat on laps. And sometimes that's the whole job. Corinne filed the trust documentation with the court. The HELOC application was flagged and suspended pending a title investigation. Glenda Forsyth claimed a residency evaporated like frost on a March morning once the bank understood who actually owned the property. But I wasn't finished. What my son didn't know, what I hadn't told him yet because I was waiting until I was certain, was what my contact at the property management company had found. He called me on a Wednesday evening, 3 weeks after the protection order was filed. He was careful on the phone, the way people who've spent decades in commercial real estate learn to be. "There's something you should know," he said. "Tell me. Your daughter-in-law has been filing expense reports for properties that don't exist. Ghost addresses. The amounts are small enough to slip through quarterly reviews, but they go back 18 months and the pattern is consistent." He emailed me a summary, 12 transactions. Total amount just under $40,000, not enormous, not nothing. I asked him what he needed from me. "Nothing," he said. "I just thought you should know before it comes up in the discovery process, because it will come up." I thanked him. Then I called Corinne. She asked me how I wanted to handle it. "I want it handled through proper channels," I said. "Report it to the company's compliance office. Let them deal with it through their own process. I don't want it weaponized. I want it documented." She was quiet for a moment. "That's a gracious choice," she said. "It's a strategic one," I said. "There's a difference." What I didn't want was for this to look like a mother attacking her son's ex-wife. What I wanted was a factual record. Courts respond to patterns, not to anger. Corinne understood this. She'd spent 30 years watching people come into family court with rage and leave with nothing because rage doesn't file well. The compliance report went in on a Thursday. My daughter-in-law's employment was suspended pending investigation 2 Fridays later. I heard about it through my son, who heard about it through a text from his wife that said simply, "I hope you're happy." He wasn't happy. He was sad and tired and still sleeping in my spare room with his son down the hall. Happy wasn't the right word for any of it. The night I heard about the suspension, I sat in my husband's chair by the front window and let myself be still for a while. This was something I'd learned to do after he died, to stop moving long enough to feel the weight of things before deciding what to do with it. I'd loved my daughter-in-law once. I'd been glad when my son found someone. I'd made room for her at this table, at this window, in the family my husband and I had built over 40 years. She'd sat in this house at Christmas and eaten my shortbread and laughed at my son's bad jokes. I didn't know what had changed. Maybe the mother had always been there, waiting. Maybe the marriage had simply eroded in ways neither of them managed well. Maybe there was no clean story. But I knew what I'd watched happen. And I wasn't going to let her keep happening to my son. The hearing was scheduled for a Tuesday morning in March, the kind of gray Ottawa Tuesday that makes you feel like winter is a permanent condition and spring is something you read about in books. I wore my navy wool coat and flat boots because the courthouse steps were always icy, and I'd learned years ago that dignity and sensible footwear were not mutually exclusive. My son and I arrived together. Karen met us in the lobby. The protection order had already been challenged on procedural grounds. The original affidavit had contained a date discrepancy that Karen had flagged immediately, and the responding officer hadn't conducted a standard risk assessment. These things matter. Courts care about process, and the process had been sloppy. My daughter-in-law arrived with her mother and their lawyer. Glenda Forsyth wore a long gray coat, and her expression suggested that she expected to win something. She looked at me once across the lobby. I nodded. She looked away first. The hearing took most of the morning. I'm not going to pretend I understood every legal argument. That's what I paid Corinne for. What I understood was the arc of it. The protection order was found to lack evidentiary foundation. It was set aside. The house returned to my trust. The HELOC application was formally withdrawn by the bank. My son's lawyer filed for primary residential custody of my grandson, pending a full custody assessment, citing the disruption to the child's primary residence and the false allegations in the protection order. The judge noted the discrepancies on the record. It wasn't a victory exactly. Family court rarely gives you something that feels like a victory. It gives you the next step, and the next hearing, and another folder for Corinne's desk. But my son walked out of that courthouse with his head up. And my grandson was already home, had been home for weeks, feeding Douglas the cat, and going to his temporary school in El Monte, where he liked his teacher and liked the porridge. That counts for something. Glenda Forsyth paused near the exit as people filed out. I don't know if she intended to say something to me or if it was simply proximity, but we ended up standing within a few feet of each other for a moment in the cold corridor. She looked at me. I thought I saw something shift in her face, not quite remorse, not quite anger, something older, something that might have been recognition. You should have stayed out of it, she said. I thought about that for a moment. That's my son, I said, and that's my grandson. I was never going to stay out of it. She walked away. I watched her go. I don't hate Glenda Forsyth. I want to be honest about that. Hating someone that age, someone who clearly believed she was protecting her own child the same way I was protecting mine, it would take more energy than I have and more certainty than the situation deserves. We were two mothers. We made different choices about what protection looks like. She chose deception. I chose preparation. The difference was 30 years of thinking carefully about what I owned and what I owed. Spring came eventually, the way it always does in this part of Ontario. Sudden and soft, the snow going from permanent to absent over about a week and a half, the maples budding before you notice. My grandson went back to his regular school once the primary custody arrangement was settled. My son started driving back to Ottawa on weekdays and coming to El Monte on weekends. We settled into something that looked like a routine. One Sunday afternoon in late April, my son and my grandson and I drove out to Pakenham to walk along the river. My grandson liked the 5-span bridge and had opinions about which rocks were best for skipping. My son seemed lighter than he had in months. He'd started eating properly again. He'd started sleeping. At some point, my grandson ran ahead and it was just the two of us walking on the path. "Mom," my son said, "I've been thinking about what you did." I watched a heron lift off the water across the river. "What about it?" He was quiet for a moment. I used to think being careful was just, I don't know, being boring, being scared. He stopped. "You weren't being scared. You were just thinking further ahead than I was." I thought about my husband planting that maple tree 40 years ago, thought about the years of driving to job sites in the dark, of learning contract law in the evenings, of setting up a trust when the lawyers told me I probably didn't need to yet. "Your grandfather used to say," I said, and I hadn't said this aloud in years, "that the work you do before anything goes wrong is the only work that matters when everything does." My son nodded. My grandson came running back with a rock he found exceptional. We walked back to the truck in the late afternoon light, the three of us, and I thought about what I wanted to say to anyone else who might be listening. Anyone sitting somewhere right now wondering if it's too late or too early or too complicated to put things in order? It's not. I'm 64 years old. I have been a wife and a widow and a mother and a business owner and a woman who had a very long meeting with an estate lawyer in 2019 that turned out to matter more than almost anything else I'd done that decade. I have sat across tables from people who underestimated me for reasons that had nothing to do with my capabilities. I have learned that quietly and without making a production of it, the person who has done their homework almost always outlasts the person who hasn't. Take care of what you've built. Know what you own and what you owe. And when someone decides your family is theirs to take apart, make sure you've already done the work to prove them wrong. My grandson is 7 now and he still feeds the cat when he visits. He still likes porridge in the mornings. He'll be fine. More than fine. We all will. I keep thinking about that backpack by my kitchen door, the one my grandson left sitting there the night my son brought him to Almonte. There was a water bottle clipped to the side and a drawing inside. I found it later, a crayon picture of our house that my grandson had apparently been carrying around since before any of this happened. He'd drawn it at school. He'd drawn it from memory. That's the thing about children. They know where home is before the adults do. I've had a lot of time this past year to sit with what happened and what it means. Not to relitigate it. I'm too old for that and too tired, but to understand the shape of it. Because when I look back honestly, the outcome wasn't luck. It wasn't even just preparation. Though the preparation mattered enormously, it was the result of choices made over decades, small ones mostly, that compounded into something solid enough to stand on when the ground shifted. Glenda Forsyth is not a villain in the way stories usually need. She's a mother who looked at my family and saw an opportunity and took it. And she took it because she believed no one had done the work to stop her. That belief was the error. Not a moral failing, exactly, though the HELOC application and the forged residency claim crossed clear lines, but a fundamental miscalculation about the person she was dealing with. I think about that a lot, about the difference between being ethical because you're afraid of consequences and being ethical because you understand that integrity is the only currency that doesn't devalue. I chose the trust structure not because I expected this. I chose it because it was the right and careful thing to do for my son's future. I documented things properly, not because I planned to use it against anyone, but because responsible people keep records. The decency came first. The protection followed from the decency. That's not strategy in a cold sense. That's just what it looks like when you spend your life trying to do things properly. And then there's my son. He's a good man who trusted too easily and didn't ask enough questions and learned something hard about what love can look like when it turns. He came through it, not unscathed. That would be too easy, but intact. And I think the reason he came through it is that when everything fell apart, he had the sense to sit down at my kitchen table and tell me the truth instead of managing appearances. That took something. That took the kind of honest reckoning with reality that a lot of people his age find very difficult. My husband used to say that you find out what a person is made of, not when things are easy, but when they have to choose between the comfortable story and the true one. My son chose the true one. I want to say to anyone sitting with something heavy right now, the work you do quietly before anything goes wrong is not wasted. The document you file properly, the conversation you have honestly, the decision you make with your head even when your heart wants to take the easier road. None of that disappears. It accumulates. It becomes the thing that holds when everything else shifts. My grandson drew our house from memory because he'd been there enough times to know it by heart. That's what I want to leave him, not the house, though it'll be his one day, but the understanding that the people who love you will do the work. They'll file the papers. They'll sit with the lawyer. They'll show up at the courthouse in sensible boots, and they will not stop. That's what I have to give. That's enough. I had just put the kettle on when my phone rang. It was my daughter. I could hear the echo first, that hollow, concrete sound, before she said a word. A parking garage. I knew it immediately because she used to call me from that same garage when she worked downtown years ago, before she married him, before any of this. Mom. That was all she said, and then she stopped. I turned off the burner. "Where's the baby? She's with me." "She's in her stroller." "Mom, Lyle's father walked into my office this morning and told me I was terminated, effective immediately. Security walked me out. And when I got home, I couldn't get in. The code doesn't work. The key doesn't work. I've been sitting here for 40 minutes. I looked at the clock on the microwave. It was 2017 in the afternoon. My granddaughter was 9 months old. "Stay where you are," I said. "I'm coming." I didn't ask questions. I didn't say what I was already thinking. I grabbed my coat off the hook by the door and my keys from the ceramic dish my daughter had painted for me in grade 4, a lopsided blue bowl with her handprint pressed into the clay, and I walked out to my car. The drive took 22 minutes. I know because I counted traffic lights. She was standing near the elevator bank on the second level, the stroller in front of her, her work bag over one shoulder, a cardboard box balanced against her hip. The kind of box they hand you when they want you gone fast. My daughter is 34 years old. She has her father's eyes and my stubbornness, and she was trying very hard not to cry. I took the box from her without saying anything. I loaded it into my trunk. I folded the stroller and clicked it into place. Then I unbuckled my granddaughter from her seat and held her against my chest for a moment. She smelled like the lavender lotion I've given my daughter at Christmas, and I buckled her into the car seat I keep in my back seat. I have kept a car seat in my back seat since the day that baby was born. We drove to my house. My daughter stared out the passenger window the whole way. I put on the CBC radio station she grew up listening to because silence felt too heavy, and I let her be quiet until we pulled into my driveway. Inside, I made the tea I'd abandoned earlier. I set a plate of crackers and the good cheese on the table. My granddaughter sat in the bouncy chair I keep in my kitchen corner and watched us with her serious dark eyes, chewing on the ear of a stuffed rabbit. Then I sat down across from my daughter and I said, "Tell me everything. From the beginning. Her name is Willa, my daughter. I want you to know that because the rest of this story is about what was done to her and she deserves to be named." Willa had been working at her father-in-law's physiotherapy clinic for 3 years. His name is Archibald Strome. Everyone calls him Arch, and he runs 3 clinics in the Vancouver area, or at least that's how it appeared. Office manager at the North Shore location, then promoted to regional administrator overseeing billing and scheduling across all 3 sites. She was good at it. She had reorganized their patient intake system and cut the billing error rate by 40% in her first year. Arch had told her more than once in front of other staff that she was the best administrator he'd ever had. Her husband Lyle worked there too in a vague senior coordinator role that seemed to shift in description depending on who you asked. They had married 4 years ago. I had concerns. I want to say that plainly. I had concerns about Lyle from the beginning, and I kept most of them to myself because Willa was happy and she was 30 and it was not my marriage. But I noticed things. The way he spoke over her at dinner. The way he deferred every household decision to his father's opinion. The way Arch would look at Willa sometimes, not unkindly, but assessingly. The way you look at a resource you're trying to calculate the value of. What Willa told me that afternoon at my kitchen table was this. Arch had called her into his office that morning, along with Lyle and a woman from what he described as their HR support firm. He told Willa her position was being eliminated due to restructuring. He slid a single-page termination letter across the desk. It had her signature line at the bottom for acknowledgement. She did not sign it. She asked what restructuring meant specifically, and Arch said they were moving administration to a centralized service provider. He said it in the tone of someone who had rehearsed it. Lyle said nothing during the entire meeting. He looked at the wall behind her head. When she got home, she entered the garage code. It didn't work. She tried her house key. It had been changed. She called Lyle and the call went to voicemail. She called again. Voicemail. She stood in the driveway of the house she had lived in for 3 years with her 9-month-old daughter in her arms, and then she walked to her car and drove to the parkade downtown and called me. I listened to all of it. I drank my tea. "Did you sign the termination letter?" I asked. "No." "Good." I refilled her cup. Where is the lease on your house? She looked at me. What? The rental agreement. Or the mortgage documents. If it's a mortgage. I think it's in Lyle's name. Or his father's. I'm not sure. I never asked to see it? I nodded. I had expected that. Okay, I said. I need you to stay here tonight, both of you. The room is made up. Mom, I don't want to. Willa. I said her name quietly. I need you to trust me for a few days. Can you do that? She looked at her daughter in the bouncy chair. The baby blew a bubble and grabbed at her own foot. Yes, Willa said. Here is what I had not told my daughter, because there had never been a reason to tell her. Because I had hoped it would never be relevant. 26 years ago, when her father and I separated, I made a decision about how I would manage what I had. We had owned a small commercial property together, a building in Port Moody that housed 2 tenants on the ground floor and a studio space above. And when we divided our assets, I took the building and he took the investment accounts. Everyone thought I had gotten the worst end of it. The accounts were worth more on paper, but I kept the building. I paid down the mortgage methodically over the following decade. I rented the spaces carefully. And 12 years ago, when the area started developing seriously, I used the equity to purchase 2 additional commercial properties, one in Coquitlam, one in Burnaby. The Burnaby property is where Arch Strome's second clinic operates. He has been my tenant for 7 years. He pays his lease to a numbered company registered in BC, which is mine. My name does not appear on the lease. It never occurred to him to investigate. Why would it? He was the successful businessman. His administrator's mother was a retired schoolteacher who lived in a house in North Vancouver. There was nothing to investigate. My daughter did not know this either. I had never connected the dots for her, the company name, my property, her workplace, because I had not wanted to put her in a complicated position, and because, honestly, it had seemed irrelevant. People rent commercial space. It's not dramatic. It became relevant the morning Arch walked her out of the building I owned. I did not act quickly. That is important. Acting quickly when you're angry is how you make mistakes. I know this about myself. For the first 2 days, I let Willa rest. She slept deeply, the way people sleep when they've been holding tension in their bodies for a very long time and have finally been allowed to put it down. I took my granddaughter in the mornings and walked her in the stroller along the seawall. I made soup. I washed Willa's work clothes, which still smelled like the clinic. On the 3rd day, I called my accountant and my property manager. I asked for a complete rental history and a copy of the current lease for the Burnaby property. On the 4th day, I called my lawyer. Her name is Bridget, and I have known her for 18 years, and she is not the kind of person who gets rattled. I told her what had happened. I read her the relevant clauses of the lease. We talked for 45 minutes. Then I asked Willa gently to show me her last 3 pay stubs and her T4 from the previous year. She got them from her bag. She had thought to take her important papers, my daughter, even in the state she was in. I had raised her well, and I spread them on the kitchen table and looked at them carefully. The pay stubs were from a payroll service company. I wrote down the company name. Then I asked her if she had any credit card statements from accounts she had opened since the marriage. She had 2 cards she used regularly. She spread the statements on the table beside the pay stubs. We went through them together. Nothing unusual. But when she mentioned, almost as an aside, that Arch had asked her about 18 months ago to sign some administrative paperwork to add her as an authorized signatory on the business accounts, standard for her role, he'd said, so she could handle supplier payments, I set down my tea and said, "Show me that paperwork." She found it in her email. A PDF attachment from a company called Strome Administrative Solutions, Inc., dated 20 months ago. She had signed it digitally without reading it carefully because Arch had called her while she was nursing the baby and said it was routine, and she was exhausted and she trusted him. I read it twice. It was not simply an authorization to manage supplier payments. Embedded in the second page in the same size font as the surrounding administrative language was a line that made her a co-director of Strome Administrative Solutions, Inc., a company I had not heard of before. I sent the document to Bridget that evening. Brigitte called me the next morning. "This is interesting," she said, which is lawyer for, "This is serious. We needed to understand what Strome Administrative Solutions, Inc. actually was." Over the following week, carefully, without alerting anyone, Bridget and I, along with a forensic accountant she recommended named Paul Obradovic, began to map it. What we found was this: Strom Administrative Solutions Inc. was not an administrative company in any functional sense. It was a structure. The 3 physiotherapy clinics operated under separate numbered companies, all of which listed Arch as sole director. But the rent payments from those clinics, along with certain supplier rebates and extended warranty fees collected from patients, flowed not to the clinic's own accounts, but through Strom Administrative Solutions before being redistributed. This was not, on its own, illegal. It was unusual accounting, but structures like this exist. What was problematic was that Willa, as a co-director she had never knowingly agreed to be, appeared on paper to have approved several of these fund movements. Arch had built himself a co-signer, someone who, if questions were ever asked, would share accountability for decisions she had never actually made. Paul flagged 2 additional things. First, there was a credit application made 14 months ago under Willa's name and her social insurance number to a commercial lender for a line of credit against one of the clinic companies. She had not applied for this credit. She had not known it existed. Second, the payroll service company I had noted from her pay stubs was registered to an address in Langley. The director of that company was Lyle. Her own husband had been paying her salary out of a company he controlled, which meant her employment status, her pay, her ROE, all of it was at his discretion. I sat with this information for 1 full day before I told Willa. I chose a Sunday morning. My granddaughter was down for her nap. The house was quiet. I made coffee and I sat across from my daughter at the kitchen table, the same table where she had done her homework 30 years ago, and I told her what we had found. All of it. Clearly, without softening it in a way that would require me to repeat myself later. She was quiet for a long time after. I signed that form while I was nursing Rosie, she said finally. I know. I didn't read it. You trusted your husband's family. I kept my voice even. That is not a character flaw, Willa. That is what people do. She looked at the table. What do we do now? Brigitte has already been in touch with a family law lawyer for you. His name is Marcus Wait, I know you said no names, but it's the lawyer's name. She didn't smile, but her shoulders dropped very slightly, which is how I know Willa is allowing herself to breathe. There are several things happening simultaneously, I said. Bridget is drafting a letter to Arch about the credit application and the co-directorship. The family law side will look at your employment situation and what it means for support. And I need to tell you something about the Burnaby Clinic. I told her. She stared at me. You own that building? I own that building? Since before I worked there. Yes. And you never told me. It didn't seem relevant. It wasn't meant to be a secret. I own commercial properties. I rent them to tenants. You happen to work in one. She was still staring at me. I could see her recalibrating. The lease, she said slowly, is up for renewal. The lease, I said, expired 6 weeks ago. We have been operating on a month-to-month arrangement since then while I reviewed renewal terms. The month-to-month arrangement was not an accident. My property manager had been in discussions with Arch's representative, Lyle, it turned out, about the renewal, and I had told my property manager to slow walk it because something had felt off to me and I had not been ready to commit to another 5 years. I had said this to no one. I had not even been able to fully articulate why. I had told myself it was just normal diligence. Perhaps it was, or perhaps on some level, I knew. Brigitte's letter to Arch went out on a Thursday. It was professional and specific. It documented the unauthorized credit application, the nature of the co-directorship Willa had been placed in without informed consent, and the payroll irregularities. It noted that my client Willa was pursuing legal advice and requested that all contact be routed through Brigitte's office. It also noted, in the final paragraph, that we were aware the Burnaby Clinic location was operating on a month-to-month tenancy and that the property owner had decided not to renew the lease. The clinic would need to vacate the Burnaby premises within 60 days per the terms of the existing agreement. I was not in the room when Arch read it, but Bridget told me later that he called her office within 2 hours. He was not calm. He asked who the property owner was. Bridget told him he could review the registered documents at the land title office. He called twice more that afternoon. Lyle called Willa that evening, the first time he had called since the day she sat in the parking garage. She did not answer. She showed me the call log and I nodded and said that was exactly right. He called again the next morning. She let it go to voicemail. He texted after that, "We should talk. There are things you don't understand." She read it to me at breakfast while my granddaughter banged a wooden spoon against her tray. "What do I say?" Willa asked. "Nothing," I said. "For now, nothing." Lyle's next contact came through a lawyer. It took them 10 days to retain one, which told us something. Their lawyer sent a letter that described Willa's departure from the family home as voluntary abandonment and suggested that her employment termination had been a legitimate restructuring. It also, oddly, raised the question of the Burnaby property, suggesting that if the landlord had ties to the dispute, the non-renewal of the lease might constitute bad faith. Our lawyer responded that the property owner's decision to not renew a month-to-month tenancy required no justification under BC tenancy law, and that the suggestion of bad faith was noted but not legally substantive. That was the last we heard on that front. What came next was slower. The forensic accountant finished his report. He submitted it to Bridget. Bridget referred it to her contact at the provincial regulatory body for healthcare professionals because what Arch had done with patient fees and the administrative flows raised questions about billing practices under the province's rules. That was no longer our file. It was someone else's problem to investigate, but we gave them what we had found. The family law process with Willa's lawyer took several months. I will not go through all of it. What I will say is this: because Lyle had controlled her payroll, her employment insurance claim was complicated. Her lawyer worked through it. Because the co-directorship had been obtained through what her lawyer characterized as misleading circumstances, the liability she theoretically held through that company was successfully argued to be unenforceable in any practical sense. The credit application in her name was flagged with the credit bureau and a fraud report was filed. The house, which had been in Arch's name, as it turned out, not even Lyle's, was not something she had equity in. That was painful. I will not pretend otherwise. What she did have was time, and her daughter, and a bedroom in my house that she was welcome in for as long as she needed it. She used it for 8 months, and then, gradually, she didn't need it anymore. There is a moment I come back to sometimes when I think about all of this. It was not a dramatic moment. It was a Tuesday evening, about 3 months after she had moved in. Rosie had just learned to pull herself up to standing by gripping the edge of the coffee table, and she was enormously pleased with herself, standing there looking at us both with a wide, triumphant grin before her knees buckled and she sat down hard on the rug. Willa laughed, really laughed, for the first time since any of this had begun, and then Rosie pulled herself up again. I think about that when people ask me how I handled it. The property, the lease, the documents, all of it. They ask as though the legal part was the important part. The legal part was just paperwork. The real thing was driving to a parking garage on a February afternoon and picking up my daughter and my granddaughter and taking them home. Everything else followed from that. Willa is working again. She found a position with a healthcare network management company, the kind of work she was already doing, but for people who actually want her there and say so. She has her own apartment now, a 10-minute drive from my house. She is looking into the requirements to complete a health administration designation that she had started and abandoned when Rosie was born. The Burnaby clinic closed. The other 2 locations are still operating under new management. Whatever regulatory process was initiated did not move quickly, as these things rarely do. I don't follow it closely. It is not my concern. Arch did not speak to me directly throughout any of this. I was not surprised. Men like that, men who spend decades constructing a version of themselves as the person who holds all the power, do not do well when they discover the ground was never theirs to stand on. Lyle sent one final message to Willa months later, which she read and did not answer. It said he thought she had handled things unfairly. She showed it to me and I said, "Do you want to respond?" And she said, "No." And that was the end of it. My granddaughter walked for the first time in my hallway, between the front door and the kitchen, her arms out to the sides for balance, grinning at both of us. 7 steps. She made it 7 steps before she sat down. 7 steps is a good start. I still keep the car seat in my back seat. I suspect I always will. I have been thinking lately about what it actually means to be prepared. Not prepared in the anxious way, the way where you lie awake imagining bad things so you can rehearse surviving them. I don't mean that. I mean the quieter kind of preparation, the kind that looks from the outside like nothing at all. Like a woman who keeps a car seat in her back seat. Like a woman who reads her lease agreements carefully and chooses not to sell a building everyone else thought was the worst half of a settlement. I did not know when I kept that Burnaby property that I would ever need it to protect my daughter. I kept it because it was a sound decision and because something in me understood, even then, that what you own quietly is worth more over time than what you display loudly. Arch Strom had spent years presenting himself as a man of substance. He had the clinics and the title and the way of walking into a room that said he had already decided how things would go. What he did not have was the ground under his own building. That gap between what a person believes they control and what they actually hold the papers on is where his whole structure eventually came apart. Not because I pushed it. I didn't need to push it. I just stopped extending courtesy he had not earned. There is something I want to say about Willa because I think it matters more than any of the legal or financial details. She is not a naive person. She is a capable, careful, intelligent woman who was placed, very deliberately, in conditions designed to make her dependent without her realizing it. Lyle paid her salary. Arch controlled her employment. The house was never in her name. Every thread of her practical life ran back through that family. This was not an accident. It was a structure, the same way Strom Administrative Solutions was a structure built to look routine and to function as a trap. What I want people to understand is that recognizing a trap after you are in it is not stupidity. It is simply what happens when someone you trust uses that trust methodically. The failure there belongs to the people who built the structure, not to the person who walked through what she thought was a normal door. What Willa did, once she understood what had happened, was not fall apart. She was angry. She had every right to be. And she was frightened. And she grieved something real. Because whatever Lyle was, she had believed in a version of him that turned out not to exist. That kind of loss is not small. I watched her carry it, and I did not try to tell her it was fine, because it wasn't fine. It was hard, and it took time, but she got up every morning. She took care of her daughter. She answered her lawyer's questions clearly and kept her documents organized and made decisions carefully rather than reactively. That steadiness, under that kind of pressure, is something I could not have taught her. It was already in her. I think about what it means to raise a daughter. You want to give them everything. Security, ease, a life without the hard edges yours had. But what actually carries a person through difficulty is not the absence of hardship. It is the knowledge, tested over years of small things, that they can think clearly when it matters, that they can ask for help without it meaning they have failed, that their own judgment is worth trusting even when someone confident is telling them otherwise. Willa knew to call me. She knew to say everything, clearly, without protecting anyone who had not protected her. She knew to wait before acting. Those are not small things. Rosie took 7 steps down my hallway on a Thursday afternoon and sat down hard and grinned and pulled herself up again. That image is what I keep. Not the lease, not Arch's lawyer letters, not the satisfaction of watching a month-to-month tenancy expire at exactly the right moment. 7 steps, then up again. That is the whole of it, really. I spotted my son sitting on a bench outside the Tim Hortons on Elgin Street, and for a second I almost didn't recognize him. He had his elbows on his knees, both hands wrapped around a coffee cup he wasn't drinking. My grandson was asleep against his shoulder, mouth open, still wearing his winter jacket with the broken zipper we kept meaning to fix. There was a hockey bag on the ground and 2 garbage bags tied at the top. Not suitcases, Garbage bags. I sat down beside him without saying anything. He looked at me and his face just crumpled, like a man trying very hard not to cry in public, which he was. She took the car, he said, and the account. I tried to get the joint account frozen, but she'd already. He stopped. Dad's name is still on the mortgage, but her father says he's going to. I don't know what he's going to do. I don't even know what I'm supposed to do right now. I put my hand on his arm. You're going to let me drive you to my place, I said. That's what you're going to do right now. He looked at the garbage bags. I don't want to. I know, I said. Come on. I'm 63 years old. I raised 2 kids, mostly on my own after my husband passed. I spent 31 years building a property management company from nothing. Started with 1 duplex in the Glebe. Ended up with a portfolio that would make my son's father-in-law, if he knew about it, very uncomfortable. He did not know about it. Almost nobody did. That was, as it turned out, exactly the right circumstance. My son. I'll call him by what I've always called him, which is my boy, because that's how I think of him even now that he's 34, married into a family that considered themselves the kind of people who mattered in the city. The father-in-law ran a mid-sized commercial real estate firm out of an office on Sparks Street with his name on the glass in gold letters. The kind of man who shakes your hand at Christmas dinner and immediately finds a way to mention a property he just closed on. The kind of man who makes you feel, without quite saying anything specific, that you are being assessed. I had met him exactly 4 times before my son's wedding. Each time he asked me what I did. Each time I said I managed some rental properties. Each time he nodded in a way that meant he had already stopped listening. I didn't correct him. I don't explain myself to men who have decided not to listen. My son had met his wife at university. She was lovely, genuinely, warm, funny, good with my grandson from the moment he was born. I'm not telling a story where she was secretly terrible all along. People change. Or maybe the pressure of her father's expectations just became too much to carry. I don't know. I'm not her. What I know is what my son told me that evening at my kitchen table, with my grandson finally asleep in the guest room and 2 cups of tea going cold between us. The marriage had been struggling for about a year. His father-in-law had brought him into the firm 3 years ago. My son has a background in urban planning, and it made sense at the time, or seemed to. But the father-in-law ran his business like a kingdom, not a company. Decisions came down from him alone. Credit went up to him alone. When a major mixed-use development my son had shepherded through the city approval process was announced at a board dinner, his name wasn't mentioned once. He'd raised it privately. Carefully. He said the conversation went sideways faster than he expected. 6 weeks later, he was let go. Performance issues, the letter said. The firm had written documentation of errors he had never made, signed off in meetings he had not attended, and then his wife told him she wanted a separation. And then the father-in-law who co-owned the house my son and his daughter had been living in, a fact that had been presented as a generous family arrangement and turned out to be something else, told my son he had 30 days to vacate. He said it by email, my son told me. He was staring at the table. 30 days. Carbon copied his lawyer. I wrapped my hands around my tea. I looked at my boy, who was trying so hard to seem like he was holding it together, and I thought about that email. Carbon copied his lawyer, like my son was a tenant, like this was a transaction. Okay, I said. Mom, I heard you, I said. I'm thinking. Here is what I was thinking. I had been in property management in this city for 31 years. I knew every commercial block in the core. I knew which landlords were overextended, which developments were behind on draws, which firms had taken on more debt than their revenue could comfortably support. I knew because I had looked into it when my son first joined the firm, not out of suspicion, just due diligence, the way I approach everything, that the father-in-law's company was carrying significant debt on 2 commercial properties in Canada. I knew that one of those properties had a second mortgage held by a private lender. I also knew, because I had lunch with a mortgage broker I'd worked with for 15 years, that the private lender in question had recently approached a holding company I had a stake in, looking to offload some of its loan portfolio. I hadn't done anything with that information yet. I thought about it now. "You're going to stay here as long as you need to," I told my son. "Don't respond to the lawyer yet. Don't respond to anything." "Mom, I can't just—" "You are going to spend the next 2 weeks being the best father you can be to your son," I said. "That's your job right now. Leave the rest to me." He looked at me the way he used to look at me when he was small, and I told him everything was going to be fine, like he wanted to believe it and wasn't quite sure he should. "Trust me," I said. I made 3 phone calls the next morning. The first was to my lawyer, a woman named— well, she doesn't need her name in this story. She's been my lawyer for 22 years, and she is methodical in a way that I find deeply reassuring. I told her what had happened to my son. I told her about the fabricated documentation. I told her I wanted to know exactly what we could do and what it would cost. She called me back 2 days later with a very thorough answer. The second call was to the mortgage broker. I asked him whether the private lender had made any decisions about the loan portfolio. He said no, not yet. I said I might be interested. The third call was to a forensic accountant I had worked with on a dispute some years back. I asked him whether, hypothetically, a company carrying the kind of debt load I described, combined with a fraudulent documentation trail in an employment matter, would be in a position to withstand serious scrutiny. He said, hypothetically, probably not. I said I'd be in touch. Here's something I've learned in 31 years of running a business in a city like Ottawa. The people who confuse confidence with power are the most exposed. Because confidence is loud and power is quiet, and when they finally meet each other, only one of them is surprised. The father-in-law was a confident man. He had gold letters on his office window. He had a lawyer on speed dial. He had a son-in-law with 2 garbage bags on a bench outside a Tim Hortons who he had apparently decided was just going to absorb what happened and move on. He had not asked, not once, what I did for a living. Not really. He had heard rental properties and filed me under not relevant. I had been not relevant for 31 years. It is an extremely comfortable position to operate from. It took 6 weeks before anything became visible. I didn't rush it. I want to be clear about that. I didn't enjoy the waiting exactly, but I understood it. You don't move until you're ready. You don't show your hand until you've seen theirs. My son was staying at my place. He'd enrolled his son in the school 2 blocks away, the one with the good after-school program. They had a rhythm. Mornings, my grandson would come downstairs and I'd have oatmeal on the stove and he'd tell me about something he'd seen on YouTube, and I'd listen and not understand most of it, and that was fine. Evenings, my son would put him to bed and then come and sit in the kitchen and we'd talk. He was angry. Of course he was angry. He'd done everything that was supposed to matter. Built a career, made a good home, been present for his kid, and he'd been erased from his own professional record and handed an eviction notice by his father-in-law. The anger was appropriate. I told him so. "I just don't understand why," he said one night. We'd had this conversation before. Variations of it. "Because he could," I said, "and because he thought there was nothing you could do about it." "There isn't really. Is there?" I looked at him across the table. "I wouldn't say that." He studied my face. "He's known me his whole life. He reads me better than most people do." "Mom," he said slowly, "what have you done?" "Nothing yet," I said. "I'm being very careful." What I had done, to be precise, was this. Through the holding company, I had acquired the private lender's loan portfolio. That included both notes on the Canada properties. I was now, quietly and without anyone at the father-in-law's firm being the wiser, the creditor on a significant portion of their debt. I had also, through my lawyer, compiled a detailed account of the employment matter, the fabricated documentation, the meeting records my son had kept on his personal calendar, the email from a former colleague who had seen the performance file and knew it was false. My lawyer said that on its own, wrongful dismissal, we had a reasonable case. Combined with the debt position I now held, not legally connected, she was careful to say, but contextually present, The father-in-law was in a more complicated situation than he understood. We waited. The moment came, as these moments usually do. Not dramatically, but practically. One of the Kanata properties had a lease renewal coming due. The anchor tenant, a regional medical imaging clinic, had been negotiating with the father-in-law's firm for months. I knew this because commercial lease renewals in Ottawa for properties of that class tend to involve conversations that move through a fairly small professional community. I knew the property manager on the building. We'd worked together years ago. She mentioned over coffee that the renewal was stalled. The tenant was hesitant. The owner had been difficult to work with. I asked, very casually, how the financing on the building was structured. She didn't know the full picture, but she knew enough. I went back to my accountant. We looked at the numbers together. If that lease renewal fell through and the clinic vacated, the building's income would drop significantly. The loan-to-value on my note would shift. I would be entirely within my rights, under the terms of the loan, to call a review. I didn't want to damage the building. That wasn't the point, and it was never the point. What I wanted was a conversation. My lawyer sent a letter. It was addressed to the father-in-law personally, as the guarantor on the loan. It noted that we had acquired the note and introduced ourselves as the new creditor. It flagged certain conditions in the loan agreement that we wanted to discuss given current market conditions. It was polite, professional, and completely terrifying if you understood what it meant. I am told, to my lawyer, that he called his own lawyer within the hour. 3 days later, we received a request for a meeting. I wore a dark gray blazer. I drove myself. I did not bring anyone with me except my lawyer, who sat beside me at the boardroom table in the father-in-law's office and opened her folder without looking up. He came in with 2 people, his own lawyer and someone I took to be a financial advisor or a partner. He was well-dressed, controlled. He looked at me across the table and I could see the exact moment he placed me, the mother. The woman with the rental properties. He recovered quickly. I'll give him that. We appreciate you coming in, he said. I said nothing. My lawyer had advised me correctly that silence in these situations is useful. You let the other side fill it. He laid out his position. The loan was performing. The properties were sound. He was confident in the portfolio. He wanted to understand the nature of our concerns. My lawyer laid out our concerns. We went through each point methodically, the lease uncertainty, the carrying costs, the provisions in the loan agreement that gave us certain rights. She was extraordinarily calm. It's one of the things I've always appreciated about her. He listened. He conferred with his lawyer quietly. And then he looked at me directly and said something that I had been wondering if he would say. "You're his mother," he said. "Aren't you?" Not a question, really. A recognition. "I am," I said. A long pause. "I don't think this is the appropriate venue to mix personal matters with business matters," he said. "I agree entirely," I said. "That's why I've kept them completely separate. This meeting is about the loan. My lawyer can speak to the other matter, but that's a separate file and a separate conversation." He looked at his lawyer. His lawyer looked at the documents my lawyer had put on the table. Here is what was in the documents my lawyer had put on the table: the wrongful dismissal file, the fabricated performance records, the calendar entries, the letter from the former colleague, and a carefully structured summary of what that documentation in the hands of an employment lawyer and, in a worst case, the Ontario Labour Relations Board would likely produce, not just financially, but in terms of the firm's professional standing and the public record of a company that operates in a city where reputation is infrastructure. We sat there quietly and let them read it. He was a man who understood leverage. I could see him recalibrating. "What exactly is it," he said carefully, "that you're proposing?" I had thought about this moment. I had thought about it for 6 weeks. I am not a vindictive person, or I try not to be. I wanted specific things for my son, and I had written them down, and my lawyer had reviewed them, and they were proportionate. I said, I want the employment file corrected. I want a letter acknowledging that my son's departure was not performance-related. I want the letter drafted by the company in language we'll agree on. I want the 30-day notice rescinded. He and his grandson should have 90 days to make proper arrangements, and that comes from the firm, not from the family. I want the severance calculated correctly under the Employment Standards Act, which it was not. I did not ask for an apology. I knew better than to ask for that. He sat with it. His lawyer whispered something. He nodded. And the loan, he said. The loan is a separate matter, I said. If the property performs, there's no issue. I'm not here to damage your business. I'm here to protect my son. He looked at me for a long moment. I think he was trying to decide if I meant it. I did mean it. I had meant it from the beginning. I'll need a week, he said. You have a week, I said. My son didn't know the specifics until it was done. That was deliberate. I didn't want him carrying the weight of it while it was happening. He had enough to carry. When I told him, sitting at the same kitchen table, same 2 cups of tea, he was quiet for a long time. You bought his debt, he finally said, a portion of it, so that you could, so that I had standing, I said. It was a business decision. It was also useful. He looked at me the way I hadn't seen him look since he was maybe 12 years old. That particular kind of look children give parents when they realize for the first time that their parent is a full human being who exists outside the story of being their parent. Why didn't you tell me you were? He stopped. I didn't know the company was that. You never asked, I said, and I never needed you to know. He rubbed his face. Mum, you're going to be okay, I said. The letter is being drafted. The severance will come through. You have time to find a proper place? I know, but you're going to be okay, I said again. You always were. He just needed to understand that you weren't alone. My grandson came downstairs then in his socks, wanting to know if there was any of the apple cake left. I told him to check the tin on the counter. He checked. There was. He took a piece and went back upstairs without ceremony because he is 8 years old and apple cake is a complete priority. My son watched him go. He doesn't know any of this, he said. He knows his grandmother has a nice house and makes a decent apple cake, I said. That's all he needs to know right now. It has been almost a year since that bench on Elgin Street. My son has a 2-bedroom apartment in Centretown, 10 minutes from me. He's consulting now on his own urban planning projects, 2 municipal contracts already, a 3rd in discussion. He's good at what he does. He was always good at what he does. He was always good at what he does. It just took being out from under someone else's name to make that visible. My grandson has his bedroom set up the way he wants it, with a poster of the senators on one wall, even though they have broken his heart repeatedly, which I feel is an important experience for developing character. He is doing well in school. He comes to my place for dinner on Thursdays, and we watch whatever documentary he's decided we should watch, and I ask questions he mostly has to explain, and it's my favorite evening of the week. The Canada properties are still in the portfolio, the lease renewed. The building is performing. It is, as I told the father-in-law it would be, simply a business matter. I see his name occasionally in the Ottawa Business Journal. He is still operating, still closing deals, still the kind of man whose name is on the glass in gold letters. I don't have any particular feeling about that. I got what I came for. What I came for was simple. My son was sitting on a bench with 2 garbage bags and a sleeping child, and someone had decided he was easy to erase. I needed that person to understand that they had made an error in their assessment. Not just of my son, of where my son comes from. I drove home after the meeting at his office and I sat in my driveway for a few minutes before going inside. It was February. The street was quiet the way Ottawa gets quiet in winter. That particular muffled stillness when the snow is fresh and nobody's out yet. I thought about my husband, who would have wanted to know every detail and also would have told me I was being reckless. He would have been wrong about the second part, but I'd have let him think what he wanted. I thought about 31 years of nobody quite realizing what was in the room with them. Then I went inside and made tea and waited for my son to come home. People ask me sometimes, not about this story, because most people don't know it, but in general, they ask how I managed to build what I built on my own, after my husband passed, with 2 kids, in a city where nobody hands you anything, and I never have a very satisfying answer for them because the truth is boring. I just kept going. I made decisions carefully. I didn't spend energy being loud when being quiet would serve me better. That's not wisdom I was born with. It's something that gets worn into you, slowly, by years of being underestimated. My son's father-in-law looked at me across a boardroom table and saw someone's mother, a woman with some rental properties, someone who had driven herself to a meeting and didn't bring an entourage. I could see him calculating, in the way that certain men do, what category to put me in. He put me in the wrong one. That's not my fault, and it's not really even his. It's just what happens when you let confidence substitute for curiosity. He was confident he knew what I was. He never thought to ask. What I want my son to take from all of this, and we've talked about it more than once, sitting at that same kitchen table, is not that his mother swooped in and fixed things. I didn't fix things. I created conditions. There's a difference. He still had to do the work of rebuilding. The consulting contracts, the new apartment, the Thursday dinners where his son tells him about things he doesn't fully understand but listens to anyway, that's all him. I just made sure the ground wasn't completely rigged against him while he did it. But I do think about cause and effect a great deal, not in any mystical sense, just practically. The father-in-law made a choice to fabricate documentation, to use a housing arrangement as leverage, to treat my son as disposable. Each of those choices had a cost he didn't account for, because he assumed the costs would be absorbed by someone with no options. He was wrong about the options, and so the costs came back. That's not justice delivered from somewhere outside. That's just arithmetic. You make decisions as though people are powerless. And sometimes you're right, and sometimes you've made a very expensive error in your accounting. I think the thing I'd want anyone to take from this, especially a woman who's been told in 100 quiet ways that she doesn't quite register, is that invisibility is not the same as weakness. I was invisible to that man for years. In hindsight, I'm glad. You can build a great deal in the time it takes someone to decide you're not worth paying attention to. My grandson has that senator's poster on his wall. He knows his grandmother makes good apple cake and has a nice house. He doesn't know the rest of it yet, and that's fine. One day, when he's old enough and it matters, I'll tell him. Not to impress him, just so he knows the women in his family are not decoration. We are not background. We are the ones who kept the lights on and knew exactly where everything was, even when nobody thought to ask. He'll understand it eventually. They usually do.
The beeping was the first thing I heard. Not my son's voice. Not his footsteps rushing through a hospital corridor. Just the slow, steady rhythm of a machine that was doing the work my heart had forgotten how to do on its own. I'm Margaret. I'm 67 years old. I live in a small house in Barrie, Ontario, the kind of house where the neighbors still wave from their driveways and the snow collects on the porch railing in perfect, undisturbed lines. I raised my son, Nathan, in that house. I painted his bedroom walls blue when he was 4. I drove him to hockey practice at 5:30 in the morning for 11 winters in a row. I sat in the front row at his university convocation with a coffee in one hand and a disposable camera in the other, crying behind my sunglasses because I didn't want him to see. My husband, Gerald, died 4 years ago. Pancreatic cancer. 61 days from diagnosis to the end. After that, it was just me, the house, and the assumption, the quiet, unspoken assumption that my son would be there when I needed him. I say assumption because that's what it was. I never asked. He never promised. I just believed it the way you believe the heat will come on when you turn the thermostat up in November. You don't think about it until it doesn't happen. It happened on a Tuesday morning in February. I had gone to my weekly seniors fitness class at the community center on Dunlop Street. Nothing unusual. I had gone 50, maybe 60 times before. I was doing a light warm-up when something shifted in my chest. That's the only word I have for it, shifted, like furniture being moved in a room above you, a slow, heavy drag. Then my left arm went wrong, and the floor came up very fast, and then nothing. When I woke up, I was in a room at Royal Victoria Regional Health Centre. There were tubes. There was the beeping. There was a nurse named Priya who smiled at me with the specific, measured warmth of someone who has delivered bad news before and was preparing to do it again. She told me I had suffered a cardiac event, moderate, caught early enough. I would recover, but I needed to stay for observation, possibly 3 to 4 days, and I would need surgery to place a stent. I said, okay. I said it very calmly, and then I asked if my son had been called. Priya paused just slightly before she answered. She said they had found his number as my emergency contact and had been trying to reach him. She said it in the tone of someone who was choosing their words with great care. I asked how many times they had tried. She said she would check. She came back. 11 minutes later I counted and told me they had made 31 calls over the past 9 hours. 31. My son had not picked up once. I didn't cry. I want to be clear about that. I lay very still in that hospital bed, with the February light coming through the window at a flat gray angle the way it does in Ontario in the middle of winter, and I simply absorbed the information. 31 calls. 9 hours. Nothing. I asked Priya if anyone had come to be with me. She said yes. She said my neighbor had come in with the paramedics and had stayed until I was stabilized. She said the woman had been there for most of the afternoon and had only just left to go home and feed her dog. My neighbor, Deborah Okafor, 53 years old, who moved in 3 doors down 2 years ago and who had since the first week she arrived made it her business to check on me in a way that never felt intrusive and always felt genuine. She left soup on my porch when I had a cold in November. She shoveled part of my driveway after the big storm in December without telling me she'd done it. I had come outside to find it half clear and her tracks in the snow, already disappearing. It was Deborah who had called 911. It was Deborah who rode in the ambulance with me. It was Deborah who had signed the intake forms when I couldn't, because there was no one else. She had put her own name down as emergency contact secondary and written next to it, in her clear, round handwriting, neighbor, no family available on site. No family available on site. I stared at the ceiling for a long time after Priya left. That evening, Deborah came back. She brought a container of jollof rice she had made that morning, even though hospital policy didn't technically allow outside food, and Priya looked at it and then looked at me and then looked away with tremendous professional neutrality. Deborah sat in the chair beside my bed for 2 hours. She didn't fill the silence with nervous chatter the way some people do. She just sat, and when I wanted to talk, she listened, and when I didn't, she was simply there. I asked her how she had known something was wrong. She said she hadn't, at first. She said she had been driving out of the community center parking lot she went to a different class, the Aquafit, and had seen the ambulance pulled up to the main entrance. She said she didn't know why, but something made her slow down. She saw them loading a stretcher. She said she recognized my coat, the green one with the fur-trimmed hood I've had for a decade. She parked the car. She ran back inside. I thought about that for a while. She recognized my coat. Nathan called on the 3rd day. By then, the stent procedure had gone smoothly. I had started sitting up and eating real food, and I had had a great deal of time alone to think. When my phone buzzed on the tray table and I saw his name, I felt something I didn't entirely expect. Not relief, not anger, exactly. Something quieter and more final. The way you feel when a decision you've been avoiding makes itself for you. I let it go to voicemail. He called again 4 minutes later. I let that go too. The voicemail notification appeared. I didn't listen to it until that evening, after Deborah had gone home and the ward had gone quiet. I put in my earbuds and pressed play. His voice was slightly rushed, the way it always gets when he's uncomfortable. He said he was so sorry. He had been at a work conference in Calgary. The hotel Wi-Fi had been unreliable. He had only just seen the missed calls. He had been very stressed with the project. He hoped I was feeling better. He would try to come up on the weekend if things settled down. If things settled down. I played it twice. Then I put my phone face down on the tray table and looked at the ceiling again. The conference was real. I confirmed that later. But 31 missed calls over 9 hours doesn't happen because of bad Wi-Fi. His phone was with him. His phone is always with him. I have watched him answer emails at Christmas dinner. I have watched him take calls during Gerald's birthday. His phone is an extension of his hand, which means he saw those calls, and he made a choice about each one of them. 31 small choices that added up to one very large one. On the 4th day, Nathan called again, mid-morning. This time, I picked up. He went through the apologies again, a bit more detailed this time, a bit more rehearsed. The conference, the bad reception, the stress of the project. He asked how I was feeling. He said he was glad the procedure had gone well. He said the drive from Toronto to Barrie was tough in winter, but he was thinking maybe the following weekend. Maybe. I said that was fine. I kept my voice even. I asked how the project was going. He talked about the project for 4 minutes. I listened. I said the right things in the right places. At the end of the call, he said he loved me. And I said I loved him too. Because I want that to be clear. But love and trust are not the same thing. And somewhere in those 4 days, while I was lying in a hospital bed with a machine tracking my heartbeat and my neighbor's handwriting on my intake forms, I had finally understood the difference. I was discharged on a Thursday afternoon. Deborah drove me home. She had already been to my house that morning and turned up the heat and left a casserole in the fridge and put fresh towels in the bathroom. When we pulled into the driveway, she carried my bag to the door without being asked and then stood on the porch and asked me, very directly, whether I wanted company or whether I wanted quiet. I said quiet. For tonight. She nodded. She said to knock or text, any hour, and she would be there. Then she walked back down the street, through the gray February afternoon, and I stood in my front hallway and breathed in the warmth of my own house and tried to decide what to do next. What I found out 3 weeks later is the part that changed everything. My financial advisor, a woman named Linda, who I have worked with for 12 years through Edward Jones in Barrie, called to ask if I had authorized a change to the beneficiary designation on my registered accounts. She said she wanted to confirm before processing, as the request had come through a third party rather than directly from me. A third party. The accounts she was referring to were my RRSPs, which I had rolled into RRIFs after Gerald died, and my TFSA. Together they held a little over $240,000. My retirement, Gerald's life insurance proceeds. The money we had spent 30 years accumulating so that I wouldn't be a burden to anyone at the end. I told Linda I had authorized nothing. There was a silence on the phone. Then she said she thought that might be the case, which was why she had called directly rather than processing the request. She said the change had been submitted by someone claiming to act under a power of attorney. She said she would need me to come in, and she would need to put the request on hold. I sat down at my kitchen table, slowly. The way you sit when your legs aren't entirely reliable. The power of attorney she was referring to was a document I had signed 4 years ago, just after Gerald died, when a lawyer had suggested it was sensible to have one in place. I had named Nathan. It was intended for a situation where I was incapacitated and couldn't manage my own affairs, a reasonable precaution. A document born from trust. He had used it while I was in the hospital. Not for my benefit. For his. I called the lawyer who had drafted the document, a man named Robert who practices out of an office on Collier Street and who I have known for 15 years. I explained what had happened. He was quiet for a moment and then said, very carefully, that the use of a power of attorney to redirect financial assets for the benefit of the attorney rather than the grantor was not what the document was intended for, and that depending on the specifics, it could constitute a serious legal problem. He said he would make some calls. I sat with that information for 2 days before I did anything. I didn't call Nathan. I didn't confront him. I had learned in the weeks since the hospital that my instinct to confront, to demand an explanation, to give the other person a chance to justify themselves, had never once produced anything useful. People who do things like this do not explain them honestly. They reframe, minimize, redirect. You end up leaving the conversation feeling like the problem yourself. So I waited. I gathered. Linda had flagged the request before processing, which meant nothing had actually transferred. Robert confirmed the power of attorney could be revoked at any time, and I revoked it. In writing, by courier, which Robert suggested, so there would be a confirmed delivery record. I also called my bank and had a flag placed on all my accounts requiring in-person verification for any changes. Then I updated my will. I had made my original will the year after Gerald died. Nathan was the sole beneficiary. The house, the registered accounts, a small amount of non-registered savings, the car, all of it. At the time, it had seemed obvious. He was my only child. Where else would it go? I sat with Robert for 2 hours on a cold Wednesday in March. When I left, the will was different. The house and the majority of the registered accounts were redirected. A portion enough to be meaningful, not symbolic, went to Deborah. Not because I owed her something, but because the will is the last true statement you make about what you valued and who showed up, and I wanted mine to be honest. I did leave something for Nathan, not nothing. I'm not a person who believes in complete erasure, but it was significantly less than before, and it was conditional on a meeting with an estate lawyer to confirm the circumstances, which Robert recommended as a protective measure. Nathan came to Barrie on a Saturday in March, 6 weeks after I had been discharged. He arrived at 11 in the morning with a bottle of wine and a box of those chocolate-covered almonds I like from Costco, and he stood in my kitchen with the easy, slightly guilty warmth of someone who knows they've fallen short and is hoping that warmth will cover it. I made coffee. I let him talk. He talked about the conference. He talked about the project. He talked about how busy things had been. He did not mention the accounts. He did not mention the power of attorney. He talked for 40 minutes, and in those 40 minutes, he did not once ask me how I had actually been, how the recovery had gone, whether I had been frightened. He asked how I was feeling. Once, in the first 5 minutes, in the way you ask before you start talking about yourself. I watched him the way you watch someone when you've stopped waiting for them to be different. After the coffee, he asked casually, as if the thought had just occurred to him, whether I had given any thought to my finances, whether I'd spoken to Linda recently. He said he only asked because, with my health situation, it might be worth thinking about some planning. He said he just wanted to make sure things were in order. I said things were very much in order. Something flickered across his face. Not guilt. Calculation. He asked what I meant. I told him, calmly, that I had revoked the power of attorney in February. I told him Linda had called me before processing the change request. I told him Robert had advised me on next steps. I told him the accounts had not changed and would not be changing. I told him the will had been updated. He was quiet for a moment. Then he said Linda had misunderstood, that he had only been asking about options, not requesting an actual change, that the whole thing had been a misunderstanding. I let him finish. Then I said that may well be the case, and that a lawyer could review it, and that I wished him a safe drive back to Toronto. He left 40 minutes after he arrived. He called twice that week. I responded to both calls with a short text, "Received your message, no need to call back," and left it at that. There are people who, when they realize the leverage is gone, will work very hard to rebuild the relationship so the leverage can return. I had watched enough women in my life navigate that particular dynamic to know I did not want to spend whatever years I had left inside it. Deborah came over that Saturday evening. I had made tea. We sat in the living room, the one with the window that faces the backyard, where the bird feeder Gerald put up in 2009 still hangs from the maple, and I told her what had happened. Not all of it, some of it belonged to Robert's file, but enough. She listened without interrupting. When I finished, she was quiet for a moment. Then she said, very simply, that she was glad I was okay. Not glad I had won something. Not glad Nathan had been caught. Glad I was okay. I thought about what that word had meant to me 6 weeks earlier. In a hospital bed in February, with the beeping and the gray light and 31 unanswered calls behind me, okay had seemed very far away. And here it was, sitting in my own living room, with tea that was the right temperature, and a person beside me who had recognized my coat in a parking lot and decided that was reason enough to run back inside. In April, I booked a trip. I had never been to the Maritimes. Gerald and I had always said we would go, and we never did. I booked a 10-day drive through Nova Scotia and Prince Edward Island in June, when the lupins are in bloom along the roadsides and the light on the water in the early morning is that specific shade of copper that you only see in certain places. I booked a room at a small inn in Lunenburg. I booked the ferry from Caribou to Wood Islands. I found a lobster shack in Georgetown that had reviews going back 11 years and a 4.5-star rating, and a woman in the photos who looked like she had been standing behind that counter since before I was born. I told Deborah about the trip over the phone. She said it sounded beautiful. I asked if she wanted to come for part of it, the PEI portion, maybe 4 days. She said she would think about it. She called back the next morning and said yes. In May, I closed the bird feeder for the summer, too much squirrel activity, and planted tomatoes in the garden boxes Gerald had built the last summer he was well. I drove to Linda's office and reviewed my accounts, which were exactly as they should be. I called Robert to confirm the will was registered and on file. Then I made a simple dinner, sat at the kitchen table with the window open, and listened to the neighborhood. The sound of someone's lawnmower 2 streets over. A dog, somewhere, making an argument about something. The particular creak of the house settling into the evening. My son did not call that week. I noticed it the way you notice the absence of a sound you'd become so used to. You'd stopped hearing it not with pain, but with a kind of adjustment, like your ears recalibrating. I thought about what Gerald would have said. He was a practical man, not prone to sentiment, but he had a gift for reducing things to their essential truth. He would have said something like, "You can't fill a house with someone who isn't there." He would have said it the way you say something obvious that needed saying anyway. He was right. I'm not a person who believes that family is only the people you were born to. I never used to say that out loud. It felt disloyal to something, but the truth has a way of insisting on itself, especially in hospital rooms in February, when the heating vents hiss and the light is flat, and the person who signed the forms has a different last name than yours. Family is also who shows up. Family is the woman who recognized your coat. The lupins in Nova Scotia are extraordinary in June. You come around a bend in the road and there they are, suddenly, great washes of purple and pink along the shoulder, and the ocean is right there below the hill, and the air smells like salt and something green and alive. I had forgotten that the world could be that color. Deborah took a photograph of me standing in front of a field of them. I have it on my phone. I look like someone who has made a decision and is done second-guessing it. That's what I am. I kept the house. I kept the accounts. I kept the bird feeder, even though it's empty till fall. I kept the tomato plants, which are doing well. I kept the green coat with the fur-trimmed hood. I kept everything that mattered, and I let go of the things that had been wearing me down for longer than I had admitted. And I started sleeping, really sleeping, for the first time in years. Not the fragmented, half-alert sleep of someone who is waiting for something. The deep, uncomplicated sleep of someone who has stopped waiting and started living. That's the whole story. That's what those 3 days in February cost me, and what they gave me back. You spend a certain number of years arranging your life around people who should be there, and then something happens, a machine beeping, a flat gray window, 31 calls going nowhere, and the arrangement becomes visible for what it is. And you get to decide what to build instead.